Yeah. So today is the day three of our webinar series. In the past 2 days, we have dealt in complete detail with certain nuances around how to draft a will, plus an introduction of succession planning. And in the last webinar, we had touched upon nascent aspects of the Indian Trust Act, trust deed, and we dealt with an interesting document by the name Letter of Wishes. So as promised, our today's day is quite important because now we are going to be understanding the profile of all the key constituents of a trust. So last time we had discussed that trust per se is not a structure, it is merely a contract. So what becomes important is you have to see the underlying status of each of the key constituents, understand the profile of each of them, and then you will be able to understand the gamut of the entire structure. Yeah. So the key constituents as far as private trust is concerned would be a settlor, a trustee, beneficiary, and a protector. So each of this particular key constituents in detail we are going to be discussing today. Again, following the same trend for each of these key constituents, wherever I understand from my experience that professionals are going wrong or there are certain controversies around it, we'll focus more on those aspects. Yeah. Yeah, agenda is the same, so I will not repeat that particular slide. So directly jumping onto the first key constituent, we'll be discussing about the settlor. Okay, so see the role of the settlor. I'm sure all of you guys would be knowing, but just bear with me for the introduction part because there are certain nuances which will help build the stage for it. Okay, so who is a settlor? The settlor is the first person who comes into picture when we are discussing about a trust, because the idea of the trust initiates in his mind. The desire, the wish to plan for his succession initiates in his mind, and then he narrows down on the tool of trust. So in a way, he can be termed as the starter of the trust because the idea starts in his mind and he initiates the entire discussion. And that is why, in a very appreciative way, the Indian Trust Act refers him as the author of the trust. Okay, so the Indian Trust Act in the entire act did not use the word settlor. They refer to the person as the author of the trust. Now, who the author is? Generally, author is the first person in whose mind the idea comes into play and who starts drafting or making that idea into action per se. So yeah, the settlor is the starter and referred to as the author of the trust. Now, what is the role of the settlor? So let us understand in a very simple way. The role of the settlor can be broadly divided into two parts. One is that of an identification, and next is that of an elaboration. Now, what do I mean by that is, for identification, the settlor in a very categoric and a specific manner has to be very clear on what is going to be the property that he wishes to plan for in the trust structure which he would like to settle. Next is the identification of the beneficiaries. Okay, as per the Indian Trust Act, it is mandatory that the beneficiaries have to be identified. See, even in specific or discretionary trust, the quantum of beneficial interest of each beneficiary can remain open. That is perfectly fine. But identity of the beneficiary is mandatory as per the Indian Trust Act. So he has to identify that. And the most important, another important part is the settlor has to identify who the trustee is, who the trustee is going to be, because without the trustee's identification, things are not going to move ahead. So if say a settlor has a thought in his mind that I know this property which I want to settle, I also have my beneficiaries identified, let me settle the trust and then in future I'll bring in the trustee. This is not permissible. In fact, as a matter of fact, property and beneficiaries can subsequently also be added or amended, but trustee is something who has to be at present as soon as the trust is going to be formed, or even before that, because there is going to be a strong discussion between the settlor and the trustee. Yeah? Then on the elaboration point of role of the settlor, he has to be quite elaborative in terms of what his wishes and desires are, because that is what he has to document as part of the trust deed or letter of wishes and also convey that to the trustee. And he has to very categorically lay down the expectations that he has from the trustee, because these expectations for the trustee are going to take form of responsibility. Yeah. So the role of the settlor broadly and in a very simple way can be understood this way. Yeah. Now moving to the next slide, where we are going to be discussing about a very niche issue. Okay, this is a very practical slide, and a lot of you will be able to relate to that because you would have seen that in your experience. See, what happens is that you will see a lot of trust deeds or trust structures where people try to play around with these words of settlor, contributor, and donor. When we put a question to them that how do you define the role of them, they actually say that all three of them in our case is going to be different. What they say is that the settlor in our case is the one who has been named as the settlor or author as part of the trust deed. Okay, so in many cases they make lawyers as the settlor who will just settle the trust with a simple 10,000 rupees. Then the real family member who has the wealth comes into play as a contributor or as a donor. So they say that that person is actually not the settlor, he is just going to contribute or donate assets to the trust. In other way, maybe he will gift the asset to the trust. Now, why do they do that is because there could be some nascent savings as far as stamp duty is concerned, and maybe some savings or some clarities under the income tax law. But let us try and understand the ground reality as per the Income Tax Act as well as the Indian Trust Act, and then let us appreciate how this particular practice can be very damaging. Okay, so see, section 3 of the Indian Trust Act, how it defines the settlor. It defines the settlor as the person who reposes or declares the confidence is called the author. We discussed about the confidence the other day. So it was very important that the settlor has to have confidence on the trustee, lay down his expectations, and the trustee has to accept that confidence, give assurity that you can trust me, and also accept all the obligations. Only when this quid pro quo happens, only then the settlor and trustee relationship takes place. So this is how the Indian Trust Act defines that. Okay. Now, for this particular part, if you say that right now settlor is giving certain property to the trustee to manage it, later on if some other property comes into play, then technically speaking the Indian Trust Act suggests that with every new settlement a new trust forms. But it becomes practically very difficult that for each particular settlement you keep on making a new trust, because you also have to have a PAN for the trust, open bank account, so it becomes administratively difficult. So the trust deed provides that any subsequent contributions from the settlor can also be accepted in the same trust unless and until the wishes, desires or expectations of the settlor changes, or the responsibility that the trustee is expecting changes. If it is not changing, then the same trust can accept new assets. Okay. What does Income Tax Act do? Income Tax Act is not concerned with settlor's role. It considers everyone as transferors. Whosoever is going to transfer asset to the trust is referred to as transferors. They are not playing around with the names. Okay. Now let us understand what is the key issue in considering all three of them as different. For the time being, let us assume three of them are different. Settlor is only the one who settled the asset. Now a person is coming into play who is just giving assets to the trust. So he is contributing assets to the trust, or he is donating assets to the trust, mostly by way of gift. Now see, what would happen is, let us take an example. There is person A who has settled the trust. Trustee is Mr. B. Okay. Now there is Mr. XYZ who is saying I am only contributing asset to the trust. In other ways, I am only gifting asset to the trust. Okay. As we had discussed as part of Transfer of Property Act, I told you that as per Transfer of Property Act, there is a provision which says that conditional gift is void ab initio. It is not permissible under the Indian context. Now see from the angle of Mr. XYZ. When Mr. XYZ says that I am in an unconditional way giving gift of assets to this particular trust, does that remain unconditional? My humble opinion is no, it does not remain unconditional. Why? Because the moment the asset comes into the trust, the obligations of the trustees override, they supervise this particular asset as well. If the Mr. XYZ would have directly given gift to the beneficiaries, it was a separate story. Right now, he has given the gift to the trust. Say, for example, this trust is a discretionary trust. So, a certain condition is attached to that. Even though it's a specific trust, but the timing of distribution to the beneficiaries might not have been decided. Again, there is a trustee's discretion over there. So, a lot of responsibilities or rights of the trustees will supervise the asset that Mr. XYZ would have given. So in my humble opinion, the asset coming in from Mr. XYZ cannot be said to be an unconditional or an irrevocable gift. So to some extent, the Transfer of Property Act might create a risk over here. It might get treated as a conditional gift, and thereby your entire trust might get treated as a void ab initio structure. So it's very important to keep this in mind. Another thing, okay, would the trustee be duty bound towards this property? See, as we discussed in the prior slide, the trustee is giving assurance that you can trust me only to the settlor. That assurance and that acceptance of confidence is not for the entire world. It is only and only specific to the settlor. Okay. And what confidence the trustee is giving to the settlor? That I will take care of the property that you are giving at this stage to me. Okay, so the property and the confidence is limited between the settlor and the trustee. Now, can someone say that if the trustee has accepted the property from Mr. XYZ, is the confidence and accepting of responsibility getting extended to Mr. XYZ? The question may be yes or no. Is the supervision of this particular property that is coming from Mr. XYZ covered as part of the confidence that he has given to the settlor? Maybe yes, maybe no. So then there could be a situation that a trustee can say that this particular property I have received, but I am neither duty bound towards Mr. XYZ and I am nor duty bound towards the settlor. So there are chances the trustee can siphon off that property, misuse it, and no one can even bring the trustee to books. So there are patent risks around this particular aspect. So my very strong recommendation would be that whenever you are drafting the trust deed, categorically mention that any person who is going to be contributing assets to the trust would assume the role of the settlor or author of the trust. Currently at this point of time, the settlor is say Mr. A, but subsequently if any other person also contributes asset to the trust, then that particular person is going to be contributing to assets to the trust by accepting the same terms and conditions in which the trust has been settled. So something of this sort of layering you will have to create, and thereafter the person can become then contribute asset. This is also a good case situation. My recommendation is that best case situation mein the wealth owner should be made settlor of the asset to remove all sort of ambiguities and issues around it. See, remember, all the trusts are very long term structures. Okay, better to not play around with those structures by creating better to not play around with those structures by creating these kind of ambiguities for saving of petty stamp duties and income tax benefits. It might create pain at the long term. So this was an important point around settlor, which I wanted to highlight. Other nascent features of the settlor must have a clear title to the property. Okay, what does a clear title means? That it should not be mortgaged anywhere. He should be legal as well as the beneficial owner of the property. So the property that he wants to transfer to the trust has to be completely free. Its unquestionable title has to be with the settlor and settlor alone. Okay, so say for example, I am a settlor. I own an immovable property, but that immovable property is jointly owned with someone else. Now I am only settling a trust for my purposes. If I am settling this particular immovable property in the trust, I have to categorically state that I am only contributing my portion of this joint property into the trust, because with regards to my portion, I have a clear title, but I cannot transfer the entire property. Other examples could be that, say for example, the settlor has certain shares. This is very common in today's family offices. The wealth owner would have a huge portfolio of shares. Now those shares are generally pledged with the broker, so that cash margin is not to be kept with the broker, and they get a huge credit trade line open for them. So they mortgage, they pledge their entire equity shareholding with the brokers for margin money. Now such pledged shares cannot be said to be clear title because there is a lien attached to that. Okay, so such kind of shares cannot be settled by the settlor in the trust. So you have to be mindful for that. Another example could be that, say for example, people say that trustee is the owner of the asset. But remember that the trustee is owner of the asset only in his capacity as a trustee, not as a beneficial owner. So the trustee, if he is owning such asset, for all legal purposes, his name would be mentioned on that asset. But he cannot settle such assets into the trust, okay, because he is not the beneficial owner of that asset. So the title has to be clear, and both legal as well as beneficial ownership of the property has to be with the settlor. Next is a settlor can be a resident as well as a non-resident. There are a lot of rumors around this thing that a non-resident person can never settle a trust in India. It is not true. A settlor can be a resident as well as a non-resident. The only caveat is, in case of a non-resident, FEMA applies to the structure. So your structure and entire planning has to be compliant with FEMA. The moment you do that, you are absolutely free to do that. Especially Indian Trust Act doesn't bifurcate between the two, or has no bias between amongst the two. Yeah, so a resident as well as non-resident both can act as a settlor. This brings the end to the discussion to settlor. Moving to beneficiary. So beneficiary is defined under section 9 of the Indian Trust Act, which says that every person capable of holding property may be a beneficiary. A very simple definition. So any person, be it an individual or a body corporate, any person who is eligible to own property in their own name can become a beneficiary in the trust. Okay. Now the question arises, a lot of you would have heard in newspapers or would have seen in your experiences, or some stalwarts giving examples that there have been trusts where massive amount of wealth has been left for unborn kids or pets in the family. Okay. Now unborn kids or pets, both of them strictly speaking would not fall within section 9 of the Indian Trust Act. So how do that happen? So there are certain court judgments and there are certain precedences. Citing those precedences, you can to a certain extent bring in this kind of beneficiaries in the trust. But income tax has a lot of restrictions around this. When we'll be discussing about the taxation aspects of irrevocable trust on Monday, I'll be covering that part. There was a very interesting Bangalore tribunal judgment in the case of Buckeye Trust that becomes very important now in this particular hindsight. So Indian Trust Act and those things will allow you. How will income tax play? That is a separate story. We'll see that on Monday. Again, beneficiary can be resident as well as non-resident, subject to FEMA regulations. Trust under trust. We discussed this the other day. So if you have a trust whose only property which is settled in the trust is beneficial interest in another trust, that is not permissible as per the Indian Trust Act. How to structure this in itself is a very detailed discussion. Maybe after this series is over, in future I'll hold a webinar specially for discussing that. So at that point of time we'll cover that in detail. Yeah. Now moving to the role of the trustee. This is one of my favorite parts when I'm discussing about the private trust. I'm sure at the end of 5-10 minutes even you'll be able to appreciate that. So we'll start with a very beautiful Supreme Court ruling. Now why I'm telling about this ruling to be beautiful is because the kind of judgment which the Supreme Court has put down in this particular ruling is extensive. So I would strongly recommend all of you all to please read this particular ruling. If not the entire ruling, Taxman provides a 2 to 3 pager summary of this particular ruling. Read that. It's going to be a wonderful read. Yeah. So first I'll just give you a brief background of the case so that you can appreciate the discussion in a better way. It's a very old ruling of 1958. At that point of time in India, there was a state tax by the name of agriculture tax. So this pertains to Uttar Pradesh. Okay. In that particular agriculture tax, if you own agricultural land and you earn income from that agricultural land, then there was a computation mechanism of your income, and thereafter a tax was levied and you had to pay that agricultural tax. Okay. Now, see, this is of 1958. At that point of time, a lot of agricultural property was owned by Britishers. They had settled trust for their future generations and they had moved back to Britain. Okay. So Mr. Holdsworth also, I believe, was one of the Britishers only. So what happened in this particular case is there was a trust, private family trust. It had many beneficiaries, and the trust owned an agricultural land and earned agricultural income. Now the agricultural tax law, what it said is, okay, if the beneficiary would have owned the property in their own name, you do a calculation, a certain amount will come. Now, if say there is an agent or a nominee who is managing the property on behalf of the beneficiaries, then the agent also has the option to pay tax in his or her own name, and there is a different computation mechanism in the hands of that agent. Now in this particular case, the tax calculation, if we do in the individual hands of the beneficiaries put together, versus the tax calculation happening at the level of agent was different. Okay, so the assessee wanted to take a more favorable position. So the Supreme Court got an opportunity to study the meaning of the term owner in relation to trust. Okay, so this is the background. Now just a pictorial depiction of that ruling. So before that, let's just focus on this point. It says that the argument was assessee was trustee and claiming that he was paying tax on behalf of beneficiaries. So any person paying tax on behalf of beneficiaries could take the beneficial provision in play. So this was assessee's argument. Now what the court ruled is, before that let me just highlight section 3 of the Indian Trust Act. See, what it says is a trust is an obligation annexed to the ownership of property arising out of a confidence reposed in and accepted by the owner or declared and accepted by him. Now the words are for the benefit of another. This another means the beneficiary. This is a very, very beautiful statement. Okay, it says who is the trustee? A trustee is someone who has accepted the property and agreed to manage it for the benefit of the beneficiary. Okay, what was the assessee's argument? Assessee said that he was claiming that he was paying the tax on behalf of beneficiary. So these are the two words, on behalf of and for the benefit of. The Supreme Court very beautifully gave distinction between these two terms. So till now most of us would also be feeling in the same way, this Dhruv is just playing around the words. It means the same thing. What is the difference between the two? But there is massive difference between the two which Supreme Court highlighted. So let us just see that. Okay. So say for example, if I am someone, I am representing a person and I am acting on his behalf, which is the first case. I am acting on behalf of someone. Then the Supreme Court said that such a person is called as an agent or a nominee. And what is the mindset of that agent or nominee? So actually Supreme Court has spoke about mindset in that ruling, which is the beauty of this ruling. So Supreme Court said that what is the mindset of this agent or nominee? And it says that, say for example, the agent is present over here in a particular situation. Okay. So he has to think in his mind, what if my principal would have been present over here in my place? What would have he acted on in this particular moment or in this particular situation? So I have to try to think in his capacity. So basically I have to step in shoes of my principal and think that if my principal was present over here, how would he have acted upon this? And accordingly he should decide and act upon. So what it says is, the agent or a nominee, his mindset should be work in a way the principal would have worked had he been in my place. Right? Now let us appreciate what Supreme Court highlighted for the term trustee. The Supreme Court said that the section 3 of Indian Trust Act does not say that the trustee is holding the property on behalf of the beneficiaries. Section 3 of the Indian Trust Act is saying the trustee is holding the property for the benefit of the beneficiary. Very, very, very important and a nascent distinction. What Supreme Court now said is, when you are acting for the benefit of someone, how your role should be is that you have to forget about whom you are representing. You think that you yourself are the beneficial owner of the asset. What do you think you would have acted upon in a way that would have benefited you in the best possible way? So don't think about the beneficiaries. If you will always take a decision that is most beneficial for you. So do it that way, assume your own role, then decide what is most beneficial for your own self, and that same decision now you have to take for the benefit of the beneficiaries. The mindset is completely changing. What the mindset for trustee would be, work in a way I would have worked had I been myself been the beneficiary. Very important distinction. Let us take a simple example which will help you understand this distinction in a very positive way. Say there is a holding company, it has a subsidiary. Now in India, minimum 2 shareholders are required. So what they generally do is they give 1 share to the director, and the director holds that share as a nominee of the holding company. Okay. Now assuming this subsidiary has an AGM which is going on, or any meeting which is going on, where the shareholders have to vote. So how will the director vote? The director will sit and think that had the holding company been in my place, I would have not been here. They would have directly hold the shares. What decision would they have taken? The same decision I will take now. That is where the director's mindset is, I am working in a way my principal would have worked. Same example, if there is a family trust, the family trust is holding shares of a company. Now, on behalf of the family trust, it is the trustee who is going to own the shares, right? He's going to hold the shares in the trusteeship capacity. So, how does the trustee have to think? Trustee has to forget about the trust or the beneficiaries. The trustee has to think that if I would have in my individual capacity holding these shares, what would I have voted for? That is the same voting that they have to do. You know, the reason I have highlighted this particular case law is, at many places during the life cycle of the trust, you will come across several disclosure requirements, several liability requirements, signatory requirements. At that point of time, always this dilemma arises that whether the trustee should sign or the beneficiary should sign. And in all those discussions, I've generally seen that people consider trustee merely as an agent. So we have to appreciate in a very strong way that the trustee has much more senior, much more active, and much more positive role to play in a trust structure as compared to an agent or a nominee. So keep this, a silent fact in mind that trustee is a very, very active role. He is not an agent. He is much, much more than an agent. Okay? And what is his role? We have discussed as part of this particular ruling. Yeah. Then, after understanding the role of the trustee, there is another ruling which is very important. So, what happened, when Holdsworth ruling came into play? So, for good 40 and odd years, everyone used to take a stand that now, since Supreme Court has said that trustee himself has to think that he is owner of the asset. So they said the trustee is the owner of the asset, and you go ahead on that lines. And a lot of things were going wrong in that particular part. So this is again a ruling of Supreme Court in case of SBI versus West Bengal Secretary. In this particular ruling, Supreme Court has already referred to the ruling of Holdsworth. So Supreme Court has referred to the decision of Holdsworth. So since this is later in date, and since Supreme Court has already referred to its own ruling, so this ruling holds a lot of heavy weightage. Now just a brief background of what this ruling was. So there was an act at that point of time by the name Urban Land Ceiling Act. This act stated that any person who is owning a vacant land which is beyond a certain permissible size, then the surplus portion of the land, the government has the right to compulsorily acquire it. Okay. And there was a caveat or a exception to that any land which is owned by the State Bank of India will not fall under the purview of this particular act. Now, in current fact pattern, there was a private family trust who was owning such a surplus land, and in that trust, SBI was the corporate trustee. So the government came, they were saying that we will be acquiring this surplus land to defend this acquisition. The assessee, SBI, took the stand that no, see, I am the trustee for this trust. So I am the owner of the property, and your act says that any property which is owned by SBI is out of the purview of this act. So you cannot take over the land. So in this particular ruling, in a very categoric way, Supreme Court said that no, you are wrong. In Holdsworth ruling, the judgment was on the role of the trustee, to appreciate the role of the trustee, whether he is acting on behalf of or for the benefit of the beneficiaries. Here, the question lies on the beneficial ownership of the property. The Urban Ceiling Act applies to the beneficial ownership of the act. So you, SBI, as a corporate trustee, you are just the legal owner of the property. You are not the beneficial owner of the property. So the judgment in a very categorically way states that trustees are only legal owners of the property and not absolute and beneficial owner. So this ruling is extremely important even in cross-border context, because when we'll be discussing FEMA in our last webinar series, you'll be able to appreciate that even under FEMA there is lot of discussions around the role of trustee and beneficiary. At that time, we will recollect this ruling and we will hold this as a principal rule that since Supreme Court has stated that trustee is the legal owner and not absolute and beneficial owner, that's period. And this particular ruling has not been overturned till date. which means that Supreme Court still holds on this particular stand. So we'll appreciate that and go ahead. Yeah. So with this, I think broad discussion around trustee is done. We can now appreciate that trustee is a split ownership. He is the legal owner and not the beneficial owner. There is section 3 of the Indian Trust Act which says that the beneficiary has right against the trustee. Why I have highlighted that is many people have a wrong notion that the beneficiaries have their right against the trust. But trust is only a contract. You cannot have any right against the contract. So the beneficiaries have the right against the trustee. Both the explanations to section 60 we have already covered, which says that a person domiciled abroad is not a proper person, and if a trust involves custody of money, then 2 trustees are required. So in the interest of time, I will not repeat that. Now coming to my last slide, which is just lasts for about a couple of minutes, is about the role of a protector. Protector is also a very beautiful role, not defined under the Indian Trust Act, but widely accepted by the courts and practically used as part of all the trust deeds. Now, who the protector is? Protector is a non-trustee watchdog. Watchdog meaning someone outside the trust structure. So not the settlor, not the trustee, not the beneficiary. Someone outside the structure who is a watchdog and safeguarding the settlor's intent. Okay. What does he do is generally he has a advisory kind of a role where maybe he provides a consent or some consultancy to the trustees wherever they are stuck with certain dilemmatic or key decisions, especially kind of decisions wherein the beneficiary's interest might be salvaged, some amendment is needed to the deed. So such kind of macro level decisions the protector can offer his consultancy and guidance to the trustee. Point to be noted, protector's guidance and consultancy is only advisory in nature. It is not binding on the trustee. Okay. So what does he do is he acts as an independent bridge and a check between family and the trustees. And whosoever is not behaving well, the protector can try and come in as a mentoring role and take care of the situation. So generally, protector is going to be someone who the family respects a lot. We in all families we have that particular mentor figure whom we all look up to him, and his advice is generally accepted as a good advice for the family. So someone of that sort can become a protector. Now a very important point, while defining the powers, duties, eligibility, succession and other areas of protectors, I have seen certain trust deeds where the protector almost at every place steps in the shoes of the trustee, or for every small and tiny thing the trustee has to take permission from the protector. This is a very, very wrong practice. The moment you do that, there are high chances that the regulator will say that you have just named this person as a protector, nothing doing, he is the trustee. So make sure that you appreciate the distinction between trustee and protector. Ensure that the protector only needs to have a guiding power and not a very strong power where he himself is stepping into the shoes of the protector, of the trustee. So the protector should not step in the shoes of the trustee. Yeah. Again, many a times what happens is people set up irrevocable trust, but the settlor is not comfortable in losing out his control. So he brings in a protector figure indirectly to exercise control on the assets which otherwise the settlor would have wanted to exercise. So all those things, if you start breaching that ethical mark, then it might create issues for your trust structure. Then I frequently get a question around the disclosures in various statutory filings, like whether the protector has to be disclosed anywhere in any of the statutory filings that the trust would be doing, or the protector in his personal filings has to report anywhere that he is protector of the trust. So the answer is clear no. The protector is not to be reported anywhere. Plus, the protector in his personal filings also does not have to disclose anything of this sort, because the protector is not having any decision-making powers, neither any signatory powers. So someone also, frequently people pose a question to me that then what is the difference between the protector and letter of wishes? In letter of wishes also you were saying a lot of, softer aspects can be happened. Letter of wishes can guide the trustees in dilemmatic situations. Protector also does that. What is the difference between the two? So you are right. The objective of the both are quite on the similar side. protector is a more alive and an active player in the trust structure, because it's a living figure. He will see how the dynamics are evolving, so he will be able to act in a more faster way. Letter of wishes is an old document with not the future context kept in mind per se. Benefit of letter of wishes is it is very discreet. Protector is named in the trust deed, so a lot of biasness can come because he is an identified figure. But letter of wishes can be complete discreet. So to that extent, even letter of wishes is a good document. So yeah, this was my comment for the protector part. Great. So thank you guys for such a patient listening. With this, we end the presentation side of webinar 3, where we have covered the role of all the key constituents. And yeah, now I'll just take a moment and I'll stop the recording, and then we'll move to the Q&A part.